Now, our knowledge of the world itself, unfortunately, is not as wide as it ought to be. We are so much concerned about the small day-to-day problems that we do not look up our head, look at the sky, have a broader vision, see things in context. This I say because of these Bangalore principles. What are these Bangalore principles? These are principles adopted by the United Nations Commission for Human Rights as a set of principles which would guide the conduct of judges all over the world. These are principles which were discussed here, later discussed in the Peace Palace at The Hague by a committee of European judges, and then circulated for the benefit of people all over the world who were concerned with maintaining a quality judicial system. And as I said, being a Bangalorean, I did not know about it until I started looking up things which were relevant to today, and I do not know how many judges in this country know about it, though it very, very intimately concerns each one of them. It is concerned about judges, how they should do their work, what kind of qualities they should possess, and this is the primary cornerstone of any judicial system. The judicial system is a reflection of the quality of the judges who man it, and it is they who must improve themselves and who must set an example which will give them the moral authority to demand the best from anyone else who has to deal with them. I will just read out some excerpts from this because I think that language cannot be improved upon. Now, what this document declares is that a competent, independent, and impartial judiciary is the protection of human rights, and the implementation of all other rights ultimately depend upon the proper administration of justice. A competent, independent, and impartial judiciary is essential if the courts are to fulfill their role in upholding the constitutionalism and the rule of law. Public confidence in the judicial system and in the moral authority and integrity of the judiciary is of the utmost importance to a modern democratic society. It is essential that judges individually and collectively respect and honor judicial office as a public trust and strive to enhance and maintain confidence in the judicial system. Now, this document goes on to set out certain standards of conduct for judges all over the world. It says, the following principles are intended to establish standards for ethical conduct of judges. These principles presuppose that judges are accountable for their conduct to appropriate institutions established to maintain judicial standards which are themselves independent and impartial and are intended to supplement and not derogate from the existing rule of law. Now, the standards which the judges are required to maintain are set out in the series of principles, and the first and foremost is independence. It says that a judge shall uphold and exemplify judicial independence, both in its individual and institutional aspects, something which we should remember always, especially in the light of what happened at the time of the emergency. A judge shall exercise judicial function independently on the basis of the judge's assessment of the facts and in accordance with a conscientious understanding of the law, free of any extraneous influence, inducements, pressures, threats, or interference, direct or indirect, from any quarter for any reason. A judge shall exhibit and promote high standards of judicial conduct in order to reinforce public confidence in the judiciary, which is fundamental to the maintenance of judicial independence. The next quality that is emphasized is impartiality. A judge shall ensure that his or her conduct both in and out of court maintains and enhances the confidence of the public, the legal profession, and the litigants in the impartiality of the judges and of the judiciary. And then the next quality is integrity. A judge shall ensure that his or her conduct is above reproach in the view of a reasonable observer. The behavior and the conduct of a judge must reaffirm the people's faith in the integrity of the judiciary. Justice must not merely be done, but must also be seen to be done. The other quality that is emphasized is propriety, a term which is rather difficult to define, but however, there is a good exposition of it here. Propriety and the appearance of propriety are essential to the performance of all the activities of a judge. As a subject of constant public scrutiny, a judge must accept personal restrictions that might be viewed as burdensome by the ordinary citizen and should do so freely and willingly. In particular, a judge shall conduct himself or herself in a way that is consistent with the dignity of the judicial office. Then I pass on to the other quality enumerated here, equality. Ensuring equality of treatment to all before the courts is essential to the due performance of the judicial office. And then competence. Competence is listed first in the preamble. It says a competent, independent and impartial judiciary. But in the listing, competence has come last, but that does not mean that a person has a right not to be competent. There is a duty to be competent. The principle is put thus: the judicial duties of a judge take precedence over all other activities. A judge shall devote the judge's professional activity to judicial duties, which include not only the performance of judicial functions and responsibilities in court and the making of decisions, but also other tasks relevant to the judicial office on the court's operations. A judge shall maintain order and decorum in all proceedings before the court and be patient, dignified, courteous in relation to litigants, jurors, witnesses, lawyers, and others with whom the judge deals in an official capacity. The judge shall require similar conduct of legal representatives, court staff, and others subject to the judge's influence, direction, or control. Since the intention of the organizers was that I should talk about the role of the bench, I thought it necessary to point out what kind of a bench are people entitled to expect and what kind of a bench is best fitted to perform the task which it has as the cornerstone of the judicial system. Now, we talked about a world-class legal system. I am very happy about the choice of the term world-class, because that is exactly what everyone must strive to be. Now, everything is global. Nobody lives in a frog in a well. The internet has broken out every possible barrier. Thoughts flow freely. People can be influenced across locations, irrespective of distances. And not to think global is a sin. One must widen one's perspective. One must have the consciousness of the best practices that prevail in one's field, in whichever part of the corner of the world that may be. So you must compare yourselves with the best that happens anywhere else and constantly ask, are we in a position to assert that we are among the best? Now, it is not that there is no universal agreement about what are the qualities which are regarded as best. Now, the document I read out from is the result of a consensus of several meetings of chief justices of different courts from different jurisdictions, from the common law countries, from the civil law countries of Europe, and all of them have been